If you were arrested for domestic violence and you have court coming up, especially if this is your first time, only time ever in your lifetime that you have ever been arrested, you might be wondering what is going to happen at the first court date. When you're facing criminal charges, the last thing that you want is to be surprised. So in this video, I'm going to be talking about 3 things that might surprise you at your first court date, unless, of course, you watch this video. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I am also the creator of a course called Defeat the DVRO, in which I teach you from start to finish everything that you need to know to represent yourself at your restraining order hearing and win. Because a lot of people, when they are arrested for domestic violence, that is the precursor to also getting served in a completely separate case with a restraining order. If you are facing a restraining order, you can get your free first class in my course via the link down below. Okay, so let's jump right in. 3 things that might happen at your very first court date in a domestic violence case that might surprise you. Number 1, the court is most likely going to issue a protective order prohibiting you from contacting the alleged victim. Now, if you are still living with the alleged victim, maybe the alleged victim does not want this case to be prosecuted but has learned that they can't just drop the charges, then that person should come to the first court date so that they can explain to the judge that they are not afraid of you, and these are things that the judge is looking for by statute, they have to, that if anything were to happen, they would call 911, and that they want the restraining order to not be put in place. And if you've already been taking classes, domestic violence classes before your first court date, then the judge is more inclined to allow the 2 of you to have contact, to continue to live in your residence as you were, while the criminal case is pending and waiting for your attorney to resolve the case. And that criminal protective order, by the way, is going to be something that the prosecution asks for, and they always ask for it throughout the entire state of California. When the prosecutor asks for a criminal protective order, they're going to be reading from the police report and stating everything that's in there as though it is a fact. And that is very upsetting, right? If you're standing there and you're thinking, but none of that is true. But this is not the time to dispute any of that, because the judge has to take into consideration not the facts, but the allegations, what the prosecution is saying that you did, when the judge is deciding whether or not to grant a criminal protective order. Now, that may or may not be surprising to you, especially if you've been trying to learn as much as you can. You've watched a lot of videos, read a lot online about this. What may be surprising, though, is that this can include your children. So if your children were present or allegedly present when some act of abuse happened, in the state of California, abusing someone in front of your children is considered a form of child abuse. And so even if you are not charged with child abuse, you're only charged with domestic violence of some kind. If the police report includes an allegation that your children were present, then your children might be included in that criminal protective order. Number 2, sometimes the prosecutor, the DA, the city attorney is going to, on the record, in court, give an offer. So if it's your very first time, it's a domestic violence case, they might say the people's offer is 3 years of probation, 60 days in county jail, 52 weeks of domestic violence classes, a $500 fine. And when you're new to this system, when you've never been in court like this before, you might think, okay, they're really out to get me, or somehow this is my sentence. But the first court date isn't a trial. The first court date is basically just a status date to see, okay, has the prosecution filed charges? Sometimes we can get charges dropped before court. You should have an attorney try to do that whenever you've been arrested for domestic violence, but especially when it's your first time. And if charges are filed, then you get a copy of the police report and they set another date. So everyone has time to review the police report. You have time as a defendant to start doing things like probation approved domestic violence classes. Your attorney and the prosecutor have a chance to start negotiating. So this isn't a trial. This isn't the end of the case. Just because the prosecutor gives you some kind of offer on the record at the first court date does not mean that that prosecutor is out to get you. They probably have barely read the police report. They were probably reading it for the first time, or maybe the second time after skimming it when they were asking for the protective order. It just means that this is their standard offer in their particular office, and that's it. It doesn't mean anything bad for your case. But sometimes when you hear that, when the prosecutor says it, and the judge says, and you don't want to take that offer, I mean, heck no, it's the first court date. You haven't done anything to try to fight the case. What, you're just going to give in? Number 3, you are not going to have a chance to give your side of the story at the first court date. You won't be asked for your story. You will not have a chance to rebut whatever is in the police report or whatever the prosecution says. That is not what the first court date is for. Basically, an arraignment technically is just, here are the charges against you. That's it. But why would you give your side of the story at this point, right? Strategically. It doesn't make any sense for you to do that because you and your attorney, before you give any story, are going to need to make sure that you get on the same page, you see what the other party said, and you see what you can say to discredit that. You wouldn't just blindly give your story. That's the same as if you had just talked to the police and told them your story at the very beginning. Now you may be thinking, yes, but I'm falsely accused. I'm an exception. I want to give my side of the story. Are you sure? Because you might be inconsistent. What you say might differ from what happened when you were really upset and you were arrested, sometimes weeks or months ago. You might also be thinking, but I'm tired of this process. I just want it to end. I've been waiting weeks or months for this court date. I just want this whole thing to be over. I want to share my side. Nobody cares about what I have to say. I hear you, but telling your side of the story at the arraignment, even if you could, even if the judge said, you know what, if they said to me, you know what, Ms. Barton, your client seems like they really want to tell their side of the story. You can't stop them. It's their right. It's their First Amendment right. Just let them speak. And my client spoke. What is that going to do? The judge has no ability to dismiss the case at that point. That's not what is before the court. That's not what the judge is deciding on at the arraignment. That's not how it works. Instead, your attorney needs to know your side of the story and use that when talking to the prosecution, when poking holes in the other side's evidence, and trying to get the charges dismissed and keep your record clean. I hope you found this video helpful. If you do have a domestic violence case in California, feel free to give me a call. You can find my number down below. You can also book a consultation via the link there. And if you did find it helpful, please don't forget to like, subscribe, ring the bell, and follow me on Instagram, TikTok, and Facebook.